Hello guys, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. The rates of payment under clause 5 for any tools, materials and stores in or upon the works of the site thereof or belonging to the contractor or procured by him and intended to be used for execution of the work or any part thereof, possession of which may have been taken by the engineer in charge under the said clause S. Stop. Para. The reduction in rates made by the engineering charge under clause 9 from the items of works not accepted as completed fully in accordance with the sanctioned specifications. Stop. The rate of payment for any class of work which is included in the additional or altered work carried out by the contractor in accordance with the instructions of the engineer in charge under clause 14 and the rates for which is to be determined under the said clause 14. Stop. The rates of payment for materials already purchased or agreed to be purchased by the contractor before receipt of notice given by the engineer in charge under clause 15 and or the amount of compensation payable to the contractor under the said clause for loss in respect of such materials. Stop. Para. The amount of compensation which the contractor shall be liable to pay under clause 17 in the event of his failure to rectify, remove or reconstruct the work within the period specified in the written intimation or the amount of expenses incurred by the engineer in charge under the said clause 17 in rectifying, removing or re-executing the work or in removing and replacing the materials or articles complained of, the reduction of rates as may be fixed by the engineer in charge under clause 17 for the inferior work or materials as accepted or made use of the amount of compensation payable by the contractor for damages as estimated and assessed under clause 23. Stop. Para. The amount payable to the contractor for the work carried out under clause 33 in accordance with the instructions and the requirements of the engineer in charge in a case where there are no specifications. Stop. The provision of section 21 of the Dispute Arbitration Tribunal Act 92 and order issued by the government in connection with this act will now apply for arbitration. The provision of Arbitration Act shall, in so far as they are inconsistent with the provision of this act, cease of to apply to any dispute arising from a works contract and all arbitration proceedings in relation to such dispute before an arbitrator court of authority shall stand transferred to the tribunal. Stop. The awards declared by the arbitrator should be speaking award giving reasons and calculations for every item of claims. Stop. The decision will have to be implemented by all the departments of the state government and public sector enterprises of Gujrat. Stop. Para. In case of dispute leading to the contractor or government of Gujarat approaching to court of law, it shall be within the jurisdiction where the site of work is situated. Stop. Para. The reference to arbitration proceedings under this clause shall not affect the right of the engineer in charge under clause 5 to take possession of all or any tools, plants, materials, and stores in or upon the works of site thereof belonging to the contractor or procured by him and intended to be used for the execution of the work or any part thereof, preclude the engineer in charge from utilizing the materials purchased by the contractor in any work or from removing such materials to other places during the period the work is stopped or suspended in pursuance of notice given to the contractor under entitle the contractor to stop the progress of the work or the carrying out the additional or altered work in accordance with the provisions of clause 14 or as the case may be or clause 33. Stop. Para. It appears that in connection with the said contract the disputes arose between the parties and therefore the petitioner called upon the respondents corporation by giving a notice on 12 to 2020 to make payment of the dues of the petitioner or to appoint the arbitrator within a period of 30 days from the date of the receipt of the notice. Stop. The said notice, though was received by the respondent corporation, the same was neither replied nor any payment was made. Stop. The petitioner therefore has filed the present petition. Stop. It is stated by the petitioner in the petition that as the respondent corporation is not notified under the Gujarat Public Works Contracts Disputes Arbitration Tribunal Act 1992, hereinafter referred to as the Arbitration Tribunal Act, the Arbitration Tribunal constituted under the Arbitration Tribunal Act would have jurisdiction to adjudicate the disputes between the parties.